Welcome to Benson on Injury Law.
Hello and welcome back to Benson on Injury Law with Paul Benson. Paul is a personal injury attorney based in Janesville, Wisconsin. He spent the last decade helping people across the state get the compensation they deserve after serious injuries. From car crashes to dog bites, he's helped hundreds of people and fought for clients in both state and federal court. I'm Kevin Rosenquist, and today's episode tackles the question, who are you actually suing when you file a claim? Paul will explain how Wisconsin's Direct Action Statute works and why filing a lawsuit after an accident doesn't mean going after someone personally. Paul, welcome back.
Hey, thanks for having me. Good to see you.
Good to see you too. Let's start with the definition here. Can you explain what exactly Wisconsin's Direct Action Statute is and why it is important to injury cases?
Sure. It's a rule of civil procedure that we have that allows you to sue the other, and let's talk about a car accident, the other driver's insurance company directly. So they're actually a party in the case, and you do not need to name, and let's use a car accident for an example, the other driver in your suit. You can just pursue whoever it is, American Family Insurance, State Farm Insurance, and go after them for the damages. And that has a lot of advantages.
What kind of advantages?
Sure. The main one is that the jury doesn't think that they are going to have to award money against a regular person and worry about whether they're going to be able to pay that judgment. Mm-hmm. I used to practice in a different state, and you were not allowed to talk about insurance, and insurance was not in the case. So a common tactic of the defense was to make it seem like this poor old defendant was going to go broke having to pay the judgment. Here, we don't have to play those games. We can just say this is against American Family Insurance, and those fears from the jury are taken away. That's the real big advantage in the case. The other advantages is, if you know someone, let's say you're a passenger in the vehicle and your friend does something, a little negligent, you get in an accident, you don't have to sue your friend. You can just sue the insurance company for the damages.
Okay. So is there any situations, are there any situations where you're suing the person?
Yes. There are times where it makes sense from a strategy perspective. Sometimes you want to, let's say in a disputed liability case where the insurance carrier is unlikely, let's say, to admit fault for the accident, you can put the driver in the case and then use that as leverage and say, we will agree to dismiss your insured driver from this action if you will agree to 100% liability, that you're 100% responsible for all of my client's damages. And that puts the defense in a tough spot, right? The insurance company, because they owe duties of good faith and fair dealing to their driver. Mm-hmm. So they should want to get their driver out of the case. And you can kind of use that to get an admission on liability in some cases. Now, if it's a really tough liability case, they're not going to do that because they are going to look out for their own interests. Sure. However, in a closer borderline case, I've used that tactic successfully to take liability off the table.
Interesting. So would you say then the majority of the time it's the insurance company paying, not the individual?
Yes, absolutely. The overwhelming majority of the time. In Wisconsin, you can file bankruptcy for any judgments against you that arise out of negligence. So if you get a large judgment against an individual, you're likely to see a bankruptcy filing. So that's why getting insurance coverage and finding an insurance policy that applies to your loss is really the name of the game to getting your client fairly compensated for what they went through.
Obviously, I would assume that a large portion of the ones that go after the person are because the person might be uninsured. Is that fair to say?
Yeah, yes, it is. So when that person's uninsured, then yes, you are going to go after that individual. An interesting dynamic there is if you have uninsured motorist coverage, then you really have to have a conversation with your own carrier and say, your own insurance carrier and say, we're going to make an uninsured motorist claim. Do you want to pursue that driver yourself, or do you want us to do it? And you kind of have to talk through that before you're allowed to make that claim, because you have to protect their interest if you're making that claim.
Sure. How does this statute change the way you handle claims here in Wisconsin compared to maybe other states?
I just think completely takes that, again, that defense tactic of making the defendant seem like um, they're not going to be able to feed their family if the jury awards a big judgment against them. So it just totally removes that and makes it a lot easier to argue damages to the jury, and ask for larger numbers, because again, you don't have to worry about how the jury is going to perceive you asking for a big jury award, a big damages award against just, a regular person. Let's say you've got a defendant who's, let's say, got a starter job. They're a young person, fresh out of school. They're not making a lot of money. A regular person on the jury is going to feel bad for them, and that's going to absolutely affect the amount of money they award. And you would have to spend a lot of time dancing around that issue in your opening statement and your closing argument and throughout the case. Mm-hmm. Here, I don't even like to have them in the case, so they're not even sitting at the defense table. So the jury is laser clear that this is going to be American Family or State Farm or Progressive paying that verdict, not, the individual driver.
Mm-hmm. So when someone does file a claim under the Direct Action Statute, what does that process look like?
Just like any other lawsuit. So you name them as the defendant on your summons and complaint. That's the document that starts the lawsuit, and you serve them with those papers, and that starts the case. Another advantage that I forgot to mention is that those insurance companies have official addresses that you can serve papers. A big problem, if you don't know the insurance company or you have to serve an individual, is that can be hard to do. And in Wisconsin, you have 90 days to serve the defendant in a lawsuit. Well, people can make it hard for you to serve them. Whereas American Family and State Farm, they can't do that. Right. They would get in a lot of trouble with our Department of Insurance if they made it hard to serve them. So it just makes the whole process a lot smoother, because you're going to be able to name that party and get them into the case, and you're going to be able to collect from them at the end of the case.
Do you find that a lot of the people you interact with don't know about this statute?
Absolutely. It is one of the most common things that people say to me is, well, I'm not a sue type of person. I'm not a lawsuit type of person. Uh-huh. I don't want to sue my friend, my neighbor. Janesville's it's a small town. People don't want to sue someone that they know or that their friends know. And this really does put that concern to the side and say, this is after, American Family or State Farm, whoever it is, they have billions of dollars available to pay claims. And all of a sudden people don't feel so bad anymore.
Yeah. I was going to ask you also, like, is it, if, people might be, kind of compassionate or they don't want to hurt someone, like you said, they don't want to hurt someone's future or finances or whatever, but this is a way that people can feel confident in still pursuing a claim instead of guilty.
Yes. And honestly, I feel the same way. I'm not trying to ruin someone's life because they happen to get in a car accident. So I'm always hoping that there's car insurance for us to go after. And again, the insurance companies, they make plenty of profit, and they have a lot of money set aside to pay claims. And what I try to talk to people who are on the fence and they have maybe have a really serious injury for themselves or their family member is say, unlike other areas of life, this is truly a zero-sum game. Either the shareholders of this insurance company are going to have that money, or you are going to have that money. There's no gray area in the middle. It's either going to stay with the shareholders or it's going to go to you.
Yeah, that would change people's opinion, I would think.
Yeah. Especially when you look up the largest shareholders of some of these insurance companies. Normally people don't feel so bad.
Yeah, I'll bet. I'll bet. Have you had clients who are hesitant to move forward and you, when you coach them through this, then they're like, oh yeah, okay, cool.
Yeah, all the time. People are much more comfortable going after an insurance company than they are going after an individual. And I think it's just more fair. It's one of the things that I think Wisconsin law gets right, that the jury should know who's actually paying the damages. Again, I think Wisconsin and Louisiana, I believe, are the only two direct action states. The other states mostly operate on the jury should never know about insurance. I think that's patronizing and unfair. And I guess the rationale is the jury can't be trusted with that information, and they may award just an unlimited amount of money against this insurance company. Right. But again, I think I'm more concerned that it's in those other states, like Illinois, for example, just across the border, it's hiding the ball. And I think the jury should just be given all the information. So I applaud our legislator on that they allow that direct action against the insurance company.
Yeah, I agree. I think I can see, I guess I can kind of see what you said there about, if someone on the jury maybe had a problem with that insurance company or an insurance company, any insurance company had I mean, let's be honest, a lot of people don't love insurance companies, right? And I mean, I know I don't like them. I'm just gonna be honest with you, so like I can understand why people might be, why there might be a concern that a jury might look at them unfairly kind of because of the fact that they're inherently not great to deal with.
Yep. But that's why it's called the voir dire process. And you get to qualify these jurors and you get to ask jurors questions. You get to ask about their biases. And if you do find a juror who is, unusually biased and can't be fair because they have such a bad view of the insurance company, well, the judge isn't going to allow that person to sit on a jury. So they're protected too.
Mm-hmm. Yeah, that's true. That's a good point. What is your message to someone listening who might think, I don't want to be that person, but they know that they need help with their medical bills?
Yeah, that's exactly what I would say. Either you're going to come out of pocket for these medical bills and your lost wages and everything that you had to deal with going through, let's say, a car accident or dog bite or whatever it is, or the insurance company that has millions of dollars, billions of dollars set aside to pay claims is going to pay that. Those are the two choices. It's a zero-sum game. Either you're going to have this money or the insurance company is going to keep that extra claim money at the end of the year. So again, I would say, is it really, what's more fair, right? Is it more fair for you to just swallow these costs because you don't consider yourself a lawsuit person? Or does it make more sense to use the tools that we have in our civil justice system to go get that money from the insurance company for what you went through?
Yeah, is it like, I mean, people are okay making claims, like, when, obviously you make a claim when you get injured or you get in a car accident, whatever. So it's just when you hit that word lawsuit or file a suit, is that when people sort of balk at it?
I think so. And it's going after someone else's policy. I think it's a good trait that people are empathetic and they think about their neighbor that going through this. So again, it's why I'm a huge fan of Wisconsin law on this, that it takes the teeth out of having to go after someone else. You don't have to do that. We're only going after an insurance policy. It's no different than, like you said, making your own claim against your insurance policy.
Mm-hmm. It's just part of the process. Yeah.
Yep.
Mm-hmm.
Everyone goes through it at one point or another.
All right. Well, thanks for tuning in to Benson on Injury Law. If you're avoiding legal action because you don't want to go after someone personally, you're not alone. But Wisconsin law is designed to make sure you're made whole without harming the people you care about. Visit paulbensonlawfirm.com to learn more or schedule a free consultation. Don't forget to subscribe to our channel and leave us a review. We very much appreciate it. Paul, always appreciate chatting with you. Thanks so much.
Hey, thanks, Kevin. Have a good one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.